One of the most important parts of being a lawyer or having your own practice is learning how to build a relationship with clients, is learning how to negotiate clients.
There'll be clients who are fairly well aware of the legal rights, and there'll be clients who have no idea as to what the legal rights are.
Please do not assume that just because the client doesn't know the law or the subject, he's an absolute idiot. He doesn't need to know the law.
See, a client conference is about you getting information from the client, you building a relationship with the client.
Ideally, if you happen to know why that client is coming to you, if this is a new client, if you happen to know why that client is coming to you in advance, then research that area of law.
One good practice which I usually follow is if a client first calls me, I just get a very short sort of introduction to his matter, so that legally at least I have some time to prepare when he's there in the conference, so I can give him the legal solution.
Understand if there are any new developments in the context of that area of law.
Most important to listen first.
And let your client talk. For the first 10 minutes, do not interrupt your client.
What he has to say, everything, good, bad, everything.
Many a time, there are facts which may not reflect in a document, but which may come across when the client is talking.
To actually get a sense from them on what the matter is about.
Try and ferret information out of clients, because sometimes they just tell you a few facts and you really have to dig and dig and dig and dig and keep questioning them, like they're under cross-examination, to sometimes get facts which are relevant for them, which they don't think are relevant and which they possibly have not told you. So don't take any fact they've given you at face value. Always cross-question them, cross-examine them, put various thoughts, processes in their mind, give them alternatives so that you get as much information possible out of them.
Also get a sense of what they want.
He is concerned with a certain commercial or let's say goal, if not necessarily commercial, a certain end that he wishes to achieve. Understand that first.
There'll be clients whose expectations from a particular litigation will be sky high. There'll be clients whose expectations can be mitigated. However, in all of these things, the lawyer has to understand what the client's requirements are and be as frank and as transparent as possible.
In order to retain a client, there is a tendency to overpitch the case to the client, saying, oh, I think you have a fantastic case. No, I'll get you the interim order.
It is never a good idea to advise a client that he will get relief in a particular matter, because that is not, of course, in the lawyer's hands.
And if you feel that the particular end is not achievable or is certainly not realistic, start setting the expectation.
So all of these expectations of the clients have to be properly managed, properly assessed, and properly answered.
Be realistic with them.
The only thing that the lawyer can do is advise the client of his correct position in law and tell him that this is what the law allows him to do and nothing beyond that.
Personally speaking, for myself, if I think a client doesn't have a very good case, I would tell my client that. So the client has a fairly good idea about what is likely to happen in court.
It is to help the client understand that the pace of his expectation may not match the rate at which the judicial system functions, and it may not be the pace at which the court understands or receives a certain point of law or even fact.
The lawyer also has a duty to advise the client of the timeline which has to be involved in a litigation.
Clients may or may not have reasonable demands. So you must know what you are permitted to do under the Advocates Act. So read the Advocates Act. We are all officers of the court, first and foremost, and then we represent our clients. And I think that is a very important ethical framework to keep in mind.
And if they're able to impress upon the client that this is the mandate that he can realistically expect, trust me, and I say this from experience, even if you fail in court and even if you're not able to deliver the goods, the fact that you've been at least open, honest and transparent with the client will ensure that you're not constantly looking over your shoulder for competition to snatch this client away.
Just give them a reasonable factual analysis and tell them that you're going to do your best. And I think that's most often than not, that satisfies most clients.
And the test of a client or the test of your relationship is not when you do well. It's when the chips are down and when the process doesn't really reward your hard work. That is when you really know whether the client trusts you enough to continue putting or reposing his faith in you.
The other thing I think which is really useful is to maintain a schedule of fees, so that when the client asks you what your fee structure is, you're not grasping for an answer or looking at the person and trying to figure out what you're going to brief them. So you have a set fee schedule and you're operating. As per that, it gives them also a level of confidence that you know what you're doing.
If this is an old client who consistently comes to you, then learn and know that it is important to maintain that relationship. By that I mean it is important to be rigorous, it is important to be consistent, and it is important to be diligent.
It's important to be responsive. I think clients really appreciate that if they send you a message or an email, that you actually get back to them promptly, especially if there's a hearing. You inform them in advance of the date of hearing, of what you anticipate is going to happen at the hearing, and if they're not present at the hearing, then you inform them immediately of the outcome of the hearing.
Because honestly, it's a wonderful situation to have lots of new clients coming to you, but it's even better not to lose your old clients, right? Because I think in the end, the practice of law, part of it is also about building enduring relationships.